Welcome to the Professional Edge. My name's Todd, tax attorney, CPA, certified financial planner, host here on the Professional Edge for going on north of 5 years. And this week we have an exciting topic that we're going to talk about, some estate planning essentials. And Happy New Year to everyone out there. We had a little chaos at the Capitol this past week. And we know that the Georgia election is over. The Democrats took over the Senate. So with that, we have some certainty regarding the administration going forward for the next couple years. And with that, a lot of individuals make New Year's resolutions, and we start off with estate planning. We've been around family members during the holidays, and with the new COVID spike and everything else, the position of being well planned for your estate comes into mind, or at least it should, because we have not discovered the fountain of youth. So therefore, we need to make sure that we have our estate plan in order. And one place you can turn to is our website, emcadvisors.com. That is emcadvisors.com. And on the right-hand side, we have a red button. It's Ultimate Estate Plan Guide. Go ahead and put your information in there, and we'll send that information out to you, because a lot of people don't know where to actually start with their estate plan. So the fundamental document that you need to have is a last will and testament. And that basically says, when I pass away, I want my personal representative to administer my estate and then to divide my property among the beneficiaries that I list at the time I list and in the amount that I list. Now, that's the key provision of that document, is it basically divides your assets upon your passing. Now, is it controlling on all the assets? The answer is no, so stay tuned and we'll decide or learn what assets are not subject to the terms and conditions of that last will and testament. So a lot of individuals will go on the website and pull down some document, or their friend will send a copy of their document, and then they'll just sign it and think it's okay. Well, here's the problem. Are you going to be cheap with planning your estate? That's the first question you have to ask yourself, because if you're cheap and you do not properly execute your last will and testament that you drafted on your own, then it's going to become null and void, and therefore we're going to rely back on the laws of descent and distribution, and therefore the state will decide who gets your amount and when they get your estate to be distributed to them. So as we all know, the state is probably not the most efficient in deciding who gets what. And just to make sure, if you pass away and you're married and you have children, your spouse is not going to inherit your estate as you may think. They will inherit a large portion of it, but your minor children will also participate as beneficiaries in your estate. And they will receive their distribution at the age of 18. There's no restriction, no requirement, so that might be a recipe for disaster. So again, half of our listeners do not have any sort of estate plan in place, and that is very unfortunate, because we all know that we are going to use this one time in the future. So again, the very fundamental document, last will and testament, it has nothing to do with your administration if you become mentally incompetent or anything such as that. So it is a document, needs to be properly drafted, executed, and then we wait until you pass away to use that document for your personal representative to collect your assets, pay your debts, and then distribute the remaining proceeds to your beneficiaries as you outline. So here's a couple key things that you'll also want to keep in mind as estate planning essentials. A lot of individuals may have some group insurance through work, and that would pay if there's an accidental death or just a regular cause of death. And who is the beneficiary designated on that? A lot of individuals name their spouse as being the primary beneficiary, and then they name their kids as contingent beneficiaries. Again, the kids may be real young, and therefore that would quote, be put in trust until the age of majority, And let's say it's a $500,000 policy, $250,000 to each kid. It comes income tax free. Have a little bit of growth, some doubling on that. Rule of 72, if we hold it for 10 years at 7.2%, it's going to double. So therefore, that minor child at the age of 18 would be receiving approximately $500,000. Now, that is a significant sum for an 18-year-old to receive without any strings attached. So as a listener here on the Professional Edge, if your group term insurance is listing your spouse as being the primary, contingent being your children are minors, that's when you need to give us a call. Something needs to change. And to set up an initial consultation, the first one's free to get things drafted. Again, if you have a simple estate plan, it's a simple fee. If you have a more complex plan, then it's going to be a more complex fee. And stay tuned, because I'm going to tell you about the bundle, and that is a extreme value for our listeners here on the Professional Edge. But in order to schedule that free consultation, 877-654-9798. That number again, 877-654-9798. Now, let's say you do have your last will and testament, and there's a misunderstanding out here in the public that if I have a last will and testament, I'm going to avoid probate. Well, that is a completely false premise, because the last will and testament is like you playing Monopoly, meaning do not pass go directly to jail. Well, the jail in this case is probate. So will is the ticket to go to probate and then administer your estate. So again, last will and testament, you are going to probate your last will and testament to get the authority to administer the estate by the personal representative. Now, if you don't draft that last will and testament correctly, then the administrator of your estate is going to have to provide an accounting to the court, which means here's all the dollars I have, here's all the interest I received, here's all the bills I paid, here's the remaining balance that I split out among the beneficiaries, here's all my costs, expenses down to the penny. Please relieve me of my obligation. So again, there might be an accounting requirement if you go to the probate court and you don't draft your last will and testament properly. So again, that's a huge burden on the personal representative. Again, if you want to be cheap, not have these essential provisions in there, then that's your choice. But there are better options. And one place to get those options is go to our website, EMC Advisors. That is Echo Mary Charlie Advisors.com. And on the right-hand side is your estate planning guide, and that will get things started in the right direction. So another key provision about that last will and testament is not all things are controlled by the distribution provisions within the last will and testament. And that's where I go back to the group life insurance. That beneficiary designation supersedes whatever you have in your last will and testament. So again, if you name your spouse as 50% and your sibling is 50%, but your last will and testament says I give everything to my surviving spouse, well, the group benefits are going to be divided 50-50 among the spouse and the sibling, the brother. It doesn't matter what that last will and testament says, these things supersede. And the other key provision of a beneficiary designation is going to be your retirement account, your 401k, your 403b, your TSP account. Those are going to supersede whatever you have in your estate planning documents. And being a tax attorney and a certified financial planner, we see that this gets dropped all the time. These beneficiaries are not coordinated. They are not addressed in the estate planning document. They are out in the left field. So being a tax attorney, having prepared over 2,000 estate plans during my practice, we also analyze the beneficiary designation on these qualified accounts, because for a lot of our listeners here on the Professional Edge, the 401k is the largest financial asset that an individual has, but yet is controlled by a simple beneficiary designation. Now, think about this. Can you name for sure who your primary beneficiary is? And we have seen where it says the estate of holder. So if your name's Bill Smith, it says the estate of Bill Smith is a primary beneficiary. Well, if you've been listening to the Professional Edge, that's probably one of the worst beneficiary designations you can have on your IRA, 401k, TSP, or 403b, because that basically lights the time bomb on the tax for that 401k or IRA. So there's a better way to structure that, and that's where we offer our listeners here on the Professional Edge. We have this COVID thing going on, and if you want to have a Zoom meeting for the first one or meet at the Cunningham Center, that's fine. The number is 877-654-9798. That number again, 877-654-9798. Also want to mention to our listeners that these are on podcast now, so we don't have to tune in at 9 a.m. on Sunday on the radio station at WDAK. We are also posting this on the podcast. Information on that can be attained either A, send me an email, or B, call in and we'll send you the link for that podcast as well. It's available on iTunes and Google Podcasts. Pretty excited about that. So if you like the show, you like what you hear, pass it on to others and say you might want to take a listen to this, because we're learning the estate planning essentials, and these might be a great thing for you to listen to as well before you do your estate planning. So again, going back to that last will and testament, it's the document which decides your plan of distribution, who's going to be your personal representatives. And for our younger listeners out there, it's also going to decide who the guardian is going to be of your minor children. So keep that in mind. Just don't walk around blindly. You know, when the tide goes out, we see who is swimming naked. Don't be that person, because bad things happen to good people, and hopefully it won't happen to you, but we don't know. There's no guarantee for tomorrow. So again, a great place to get some information to get started is at our website, emcadvisors.com. That is Echo Mary Charlie Advisors.com. On the right-hand side, there's the estate planning guide. Click that. We'll be glad to send that out to you and get things started in the right way. We're going to have more coming up here on the Professional Edge on estate planning essentials after the break. Stay tuned.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney CPA for over 15 years, Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.